Well, wage theft is when an employer exploits workers, usually in the form of not paying overtime for hours that are worked more than 40 in a week. With the recession, we see more and more instances of employers working their employees longer hours and not wanting to pay or refusing to pay them overtime or time and a half their regular rate of pay for those overtime hours because it cuts directly into their profit margin. So employers, rather than hiring more employees, they are working their existing workforces harder. They're paying overtime. They're not paying overtime. They're refusing to pay overtime in violation of the law. This is a widespread phenomenon across many, many industries. Well, I would say there are many misconceptions about what the law requires. One of those misconceptions is that if an employee is paid salary, they're not entitled to overtime. This is a misconception that some employers share, even some sophisticated employers. That's not what the law says. The law says that if you're paid on an hourly basis, you have to be paid overtime for any hours you work over 40 in any week, regardless of the duties that you perform. Now, even if you're paid a salary, you might be entitled to overtime. In fact, you are entitled to overtime for those overtime hours unless the employer can show, and it's the employer's burden, that the employee is either an executive, an administrator, or a professional. There are a couple of other exemptions as well, but those are the principal exemptions. And it's not difficult it's not easy, rather, for an employer to prove that an employee fits within one of those exemptions. Well, under the Fair Labor Standards Act, employees are entitled to their unpaid minimum wage if they haven't been paid minimum wage, which is quite low. It's $7.25 an hour. But in most cases, we're dealing with an overtime issue. So what an employee would be entitled to, suing under this law, would be their unpaid wages, going back as far as 3 years, their unpaid overtime. Their overtime is calculated on the basis of time and a half their regular rate of pay. So if they're paid $10 an hour, then for every hour that they work over 40 in a week, they have to be paid $15 an hour. They can recapture all of that unpaid overtime going back 3 years. And in addition to that, they would be entitled to what we call liquidated damages, which is a doubling of everything that's owed. So you can see that going back over 3 years, this could be a very considerable sum of money that employees are entitled to. Finally, employees would also be entitled to payment of their attorney's fees and their court costs. So it doesn't cost the employee anything to retain a lawyer and bring one of these cases because their lawyer can expect to be paid as part of the employee's damages. The employee doesn't have to pay anything to bring one of these cases because as their attorney, I'm paid by the defendant. There is in this statute what lawyers would call a fee shifting provision. Okay, what that means is if the employee wins, then the employee is entitled to have his attorney's fees paid and also his out-of-pocket costs, including filing fees. My firm will advance any of the filing fees and will be paid at the end of the case. Also, my firm's fees will be paid from any settlement or judgment, and those attorney's fees, they accumulate or accrue on an hourly basis. So there's a powerful incentive on the part of the employer to settle these cases. Many times the employer doesn't have any defense to the case at all, but the employer is going to end up paying not just his own lawyer, but the employer is going to end up paying the employee's lawyer as well, your lawyer. And so prevailing rates being what they are, $400 an hour in many instances, that employer is going to end up paying not just what he owes you for the unpaid overtime, times two, because you're entitled to what's called liquidated damages, which is a doubling of the unpaid overtime. But that employer is going to end up paying his own lawyers to the tune of maybe $400 an hour, and my fee to the tune of $400 an hour. So that fee shifting provision is a powerful incentive for the employer to come to the bargaining table and settle these cases. And the vast majority of these cases that I've handled end up settling, often within 4 to 6 months of having been filed. The results that I've gotten in these wage and hour cases have been overwhelmingly favorable. There's the odd case here and there with interesting areas of the law that don't come down in favor of my clients. They're extremely rare in this area. And also there's the rare case where an employer is bankrupt and it makes recovery difficult or impossible. But except for those unusual circumstances, virtually every case that I have brought, and I've brought dozens and dozens of these cases over the years, has resulted in money for my client, and often very significant amounts of money, upwards of tens of thousands of dollars per plaintiff. I've had multi-plaintiff cases that have settled for hundreds of thousands of dollars. Well, employers violate the Fair Labor Standards Act and steal your wages in a number of different ways. I often see, quite to my amazement, or at least I used to be amazed by it, that employers will go to the trouble of hiring a company that will do their payroll, and the payroll is done accurately. This law requires employers to keep an accurate record of the hours worked by their employees and the time that they work, and the payroll companies will do that. But the employer will simply not pay the overtime premium. So you'll have the employer's own records showing that the employee, say, worked 50 hours in a week or 50 hours every week and was paid, say, $10 an hour, but was never paid the time and a half overtime premium for the hours over 40 in a week. Those are easy cases to win, as you might imagine. Other ways in which employers violate this law include misclassifying employees, simply paying an employee on a salaried basis, but this employee doesn't fall within one of the so-called exemptions to the Act. You often see employers characterizing employees as supervisors or exempt executives when they don't supervise 2 or more employees, when they don't have the power to hire and fire, for example, which are requirements in order for the employer to make use of that exemption. And remember, it's the employer's burden to show that the exemption applies. So that's another way in which employers circumvent this law or seek to circumvent this law. And another scheme, if you will, is for employers to misclassify employees as independent contractors. An employee or a worker is an independent contractor only if the employer doesn't have control over the employee's work. An independent contractor would be somebody like a painter you hire to paint your house. You don't tell him how to paint the house. He doesn't work just for you. He works for a lot of people. He's a business person. He's an independent contractor. On the other hand, if you operate a paint company and you provide the supplies to your workforce and you tell them that they have to be at work at a certain time and you supervise their work, those painters are not independent contractors. They're employees, and they're subject to the protections of this law. So you often see in certain industries, like the construction industry in particular, widespread violations. Employees mischaracterized, misclassified as independent contractors when they're clearly employees. And those employees are being subjected to wage theft on a large scale. Well, you start with the idea that every employee is presumed to be entitled to minimum wage and time and a half overtime under this law, under the Fair Labor Standards Act. And it's the employer's burden to show that any particular employee is not covered by the Act. So you can have a wide variety of employees who are covered by this Act, even those you might think wouldn't possibly be subject to the Fair Labor Standards Act and be entitled to time and a half overtime. Highly compensated employees, for example, engineers. I've had a case involving engineers who were paid on an hourly basis. If an employee is paid on an hourly basis, the employer cannot claim any exemption. You don't even get to the question of what duties the employee performs. So you have, in the government contract setting, for example, highly skilled employees who might actually qualify for an exemption. Perhaps they would qualify for the professional exemption if they're engineers, for example. But because they're paid on an hourly basis, there's no exemption possible for that employer. And if they're being paid $50 an hour, I mean, their overtime rate is $75 an hour. There could be a lot of unpaid overtime, and if you multiply that by 2, because they're also entitled to a doubling of their damages under the liquidated damages provision, that's a big case. So that's an instance of how there's a presumption that every employee is covered by this law. We've talked a little bit about independent contractors as well, and how they're misclassified, that they're really employees. So you start with the idea that everybody's covered, and it's the employer's burden to show that they're not covered. Probably the biggest misconception under this law is the idea that because an employee is paid a salary as opposed to being paid on an hourly basis, they're not covered by the overtime laws. That's simply false. The employer has to show 2 things. Number 1, they have to show that the employee was paid on a salary basis. If you're paid on an hourly basis, you're covered by the law. It doesn't matter what you do. We don't even get to the question of what you do. But even assuming that the employee is paid on a salary basis, the employer has got to fit the employee within one of the exemptions to coverage. The 3 major exemptions are the professional exemption, the administrative exemption, and the executive exemption. Taking the last of them first, the executive exemption, you often run into the situation where employees, say in the construction industry, have some kind of supervisory role. They might be what we call working foremen. They direct the work of other employees, but they're working alongside those employees. Unless supervision is the primary part of their job, unless they have the power to hire and fire employees, unless they direct the work of 2 or more employees, then the employer can't fit them within that exemption. Administrative exemption, that involves independent discretion and judgment on the part of an employee as a major part of their job. You have to have office or non-manual work that the employees are performing, and the employee has to have the kind of authority and independent discretion that would enable them to, for example, make policy for the company. Not a lot of employees fall within that category. And lastly, the professional exemption, it's what you might expect it to be. Certain employees, registered nurses, engineers, doctors, lawyers, they have to have education and a degree and often a license to do what they do. Those employees, generally speaking, fall within the professional exemption. Not very many employees, other than the ones I've just mentioned, would fall within that exemption. So you see, you really do start with the idea that everybody's covered. And just because you're paid salary doesn't mean you're not covered. And just because you're a supervisor doesn't mean you're not covered. Employers may think that they're satisfying the requirements of the law, but employers are notoriously ignorant about what this law requires. Violations of this law are very widespread in the economy. It's been estimated that upwards of 80% of employers are violating the Fair Labor Standards Act in some way. So you can see that ignorance of this law is widespread on the part of employers. They take advantage of it, and they steal your wages because this is what you're entitled to under the law. And I don't see how it's in any way inaccurate to call this what employers are doing when they're not paying you what you're supposed to be paid under the law, anything other than wage theft. Well, in this part of the country, if we're talking about Virginia cases, we could handle cases other than Virginia cases in association with other lawyers, but if we're talking about Virginia cases, we have the benefit of what's called the rocket docket in the federal court system. The rocket docket means that cases proceed from start to finish in a very expeditious way. Typically, your case will be set for trial well within a year of when it's filed, more like 9 months typically. That may not sound like it's very quick, but in terms of lawsuits, it can be extremely quick. Now, the rocket docket feature, together with other aspects of this law, which I'll go into in a second, work together to produce results, usually in the form of settlements, very rapidly for clients in this area. And I'll tell you how they work together. The employer, defendant, is gonna be aware through his lawyer that a trial cannot be delayed in this case, that trial is staring them in the face, that they and their attorney have to work on the case, that if they have no defense to the case, which is very, very common in these cases, that they're going to have to come to terms with that very quickly. They cannot simply sit on the case. It's going to be coming to trial. Work is required to prepare for trial, and they're going to have to pay their attorneys for that work. The flip side of that is they're going to have to pay your attorney. They're going to have to pay me if I'm your attorney, because one of the categories of damages that an employee can recover in these cases is attorney's fees. In fact, recovery of attorney's fees is mandatory if you win the case. So what the employer is looking at is a case that in most instances they don't have any defense for, at least in many, many instances. If they lose the case, not only do they have to pay their own attorneys $300 or $400 or more an hour to defend the case, they're going to have to pay your attorney $300 or $400 an hour to go forward with the case, to prosecute the case. So you might be looking at $800 an hour if you're an employer sued under this statute. So the longer the case continues under the rocket docket, where the option of sitting on the case and doing nothing doesn't exist, the more attorney's fees accrue, the more the employer has to pay out of pocket for his attorney, the more the attorney is going to have to pay for the employee's attorney, for your attorney, and it doesn't make any sense at all for an employer not to come to the bargaining table right away in these cases. It is common for situations to arise where an employer ends up paying your attorney more than they would be required to pay you, even with the double damages provision of the law. I've worked on cases before where we recovered 200% of the unpaid wages in a case for one of our clients. But because the defendant didn't want to settle the case, didn't want to talk about settling the case, they ended up paying 3 times what they paid to my client in attorney's fees. Didn't subtract a penny from what the client recovered. The client not only recovered everything that they were entitled to, but because the employer didn't settle the case right away, didn't think about settling the case right away, they got stuck with my attorney's fees. So there is this built-in incentive for the employer to come to the bargaining table rapidly. And given how quickly cases proceed to trial in Virginia, under our rocket docket system, the luxury of delaying or waiting doesn't exist. So you could be looking at a settlement within a few months of filing your case. Your employer is prohibited legally not only from firing you for bringing one of these cases or even making a complaint that you're not being paid according to the law. Your employer is prohibited also from retaliating against you in any way, in any significant way, in any material fashion. And often when existing employees make a claim, could even be an internal claim for unpaid overtime or file a complaint, there will be retaliation. But the employer will learn very quickly that they're adding to their woes by retaliating against an employee who is an existing employee and who has complained that they're not being paid according to the law under the wage and hour laws. The retaliation cases open up the possibility of even greater damages for the employer. The employer can be responsible for damages for pain and suffering. The employer can be responsible for lost wages if a firing occurs. The employer can be responsible for other lost wages and benefits if, for example, salaries are cut in retaliation for an employee asserting his rights under the Fair Labor Standards Act, under the wage and hour laws, or depriving the employee of hours. I've worked on cases where employee hours have been slashed, even though the employee was being paid improperly and wasn't being paid overtime. Employee hours were slashed. That was considered to be retaliatory because it was done in response to the employee's complaints about not being paid according to the law. So the anti-retaliation part of this law is very powerful. Well, if you are an undocumented worker or you're not working legally according to the immigration laws of this country, you can bring a case under the Fair Labor Standards Act for unpaid overtime or unpaid minimum wage. Violations of this law involving undocumented workers are very widespread because these workers are the most vulnerable workers in society. They are much more subject to exploitation and being taken advantage of than the larger workforce because they are illegal and they can be threatened with things that under this law are not going to happen to them, because not only can you not be deported or otherwise retaliated against in any way because you assert your rights as an undocumented worker to overtime wages or minimum wages, but the employer in the course of a lawsuit can't even ask you about your status. It's completely prohibited to even ask the question, to seek that information at all. The courts will cut that off before the information would be required to even be given to them about your status, about whether you're documented or undocumented. You've earned those wages, and the law is very clear that whether you were working here legally or not, that's an earned benefit, and you're entitled to it. And you're entitled to your unpaid overtime, you're entitled to your unpaid minimum wage, you're entitled to have those damages which you can capture for a 3-year period doubled under the liquidated damages provision, and you're entitled to payment of your attorney's fees and your court costs. It doesn't matter whether you're documented or undocumented. And the employer can't retaliate against you legally for bringing one of these cases. It's very common for employees to come to me and talk with me about their fears if they are currently employed by an employer who is stealing their wages, who is not paying them according to the law. And I would like to emphasize that there are protections for employees built into the law. If your employer retaliates against you for even raising the issue of not being paid properly under the law, you can bring a case against that employer for retaliation. There's safety in numbers. Often I end up bringing cases on behalf of not merely one employee, say the first person who comes to me, but many other employees in the workforce, because it certainly is rare that if an employer is not paying an employee properly, that's the only employee that's not being paid properly. It's very common for a large number of employees, a whole category of employees, not to be paid properly, to be subject to wage theft by their employer. And if one employee comes to me, more are going to join. There are ways in which we can protect you if you bring one of these cases, protect you against retaliation. There are ways in which we can expand the number of people who are going to be bringing one of these cases against an employer who isn't paying them properly and is stealing the wages of the employees. We can bring what's called a collective action, which would give every employee in the company who is similar to the employee who's suing an opportunity to merely sign a piece of paper and become a part of the case without any more hassle or burden, or without even coming to see an attorney, actually. So there are many ways that you can be protected under this law for asserting your rights to fair treatment, to payment for your wages according to the law. And there are many ways that we can ensure that more people who are being taken advantage of can participate in the lawsuit, and there's safety in numbers, because an employer is not going to fire its whole workforce, even if it was lawful for them to do so, and it isn't lawful for them to do so if they're doing it in retaliation for employees asserting their rights to fair treatment and fair pay under this law.